Hello viewers, I am Dr. Neha Kapoor Chawla. The title of today's lecture is Dissolution of Marriage under Hindu Law 1. Today we will be discussing the kinds of matrimonial remedies that are available for dissolution of marriage under Hindu law in our country. I hope this lecture will add on to the existing pool of your knowledge and will be beneficial for you. The objectives of this module are, firstly, to know the theories of divorce under Hindu law. Secondly, to understand the nature of matrimonial remedies available under Hindu law. To study the requisites for filing of an application for restitution of conjugal rights. Fourthly, to examine the grounds available for judicial separation under the Hindu Marriage Act of 1955. And lastly, to understand the differences between the nullity of marriage and divorce. So, my dear students, let us now begin with the introduction of the topic. In ancient India, the separation of husband and wife under Hindu law was viewed as an unacceptable fact related to a couple. This meant that the conjugal tie could never be cut off. Though Kautilya's Arthashastra mentions that marriage may be broken by a common consent, Manu, in his religious text, contended that the obligation of a wife continues even after her death. However, the concept of marriage today has undergone a massive transformation and is based on the principle of equality and mutual rights and obligations of the husband and the wife. In order to strengthen this proposition, the concept of divorce was introduced on the basis of certain established theories of divorce. These theories of divorce are an acceptance of the fact that the Hindu law recognizes the rights of both the parties in a marriage, and in the event of subsisting fault by either party or a non-performance of the conjugal obligations, the other party can dissolve the marriage. Thus, a party to a marriage can seek any remedy under the law, depending on the nature of the relief that is sought. Divorce is considered to be completed by a decree or order by the court on any of the grounds provided under the Act. In the latter portion of this lecture, we shall discuss the remedies in depth. Now, my dear students, let us move on to the first topic, that is the theories of divorce under the Hindu Marriage Act 1955. Under the Hindu Marriage Act 1955, there exist the following theories of divorce. The first is the fault theory under section 13 subsection 1, the mutual consent theory under section 13b of the Act, the irretrievable breakdown theory under section 13(1)(a) subclause 1 and 13(1)(a) subclause 2. Then the customary divorce theory provided under section 29 subsection 2. Now students, let us talk about in detail about the fault theory of divorce. The fault theory of divorce provides that if either party to a marriage is at fault due to the commission of a matrimonial offense such as adultery, cruelty, rape, desertion, child marriage, bestiality, the maintenance to the wife, etc., then divorce can be granted. The only drawback of this theory is that if both the parties are at fault, then divorce would not be granted. This theory is also known as the guilt theory. In other words, if either the husband or the wife has been guilty of an offense, then the other party gets the right to dissolve the marriage. Next is the mutual consent theory. As per this theory, if the parties to a marriage are unable to live together due to any reason, such as incompatibility, frequent fights between them, non-fulfillment of the conjugal rights, etc., then they can together seek to dissolve the marriage. This theory is based on the premise that marriage is a consensual union between the two people, and if no one is able to live with each other, then they can mutually decide to get separated. The third important theory is the irretrievable breakdown theory. The irretrievable breakdown theory is based on the premise that even if either party is not at fault, the marriage still can't survive. It seeks to recognize the fact that if the relationship or the love and respect between the parties has ended, then their marriage has broken down and can't be repaired or recovered by any means. This may be due to the circumstances of the parties or simply due to their non-acceptance of each other anymore. And hence, there is no possibility for the spouses to live together. This theory has also often been criticized on the point that it would allow the parties to seek divorce at their pleasure, and the guilty spouse could take advantage of his own fault by getting separated and dissolving the marriage. And the last theory of divorce is the customary divorce theory. This theory provides that a marriage may be dissolved if the custom of the parties permits so. Additionally, the court will accept the parties' use of the accepted customs or practices in their community when seeking a divorce under this theory. In addition to this, if there is a right given to a party in any special enactment applicable to his or her community, they can also apply for dissolution of marriage, irrespective of whether such a right is provided under the Hindu Marriage Act or not. And the right under this theory is also available in cases where the marriage is solemnized before or after the commencement of the Hindu Marriage Act 1955. Now, my dear students, let us move on further on the lecture with the matrimonial remedies under Hindu law. The matrimonial remedies that are provided under the Hindu Marriage Act 1955 consist of the following. First is the restitution of conjugal rights. Secondly, judicial separation. Thirdly, nullity of marriage. And the last is divorce. Now, let us start with the provision and the judicial interpretation of restitution of conjugal rights. The matrimonial remedy provided under Section 9 of the Hindu Marriage Act 1955 enables a party to a marriage to seek a decree for the restoration of the marriage if the other party has withdrawn from the society of the former party. Under this provision, a spouse who is at fault for intentionally staying away from the other party can be asked to return to the matrimonial home. Thus, it can also be inferred that Section 9 is the marriage-saving section. In order to file an application for restitution of conjugal rights, it must be examined that firstly, the spouses must not be staying together. Secondly, the withdrawal of a party from another must have no reasonable ground for such withdrawal. And thirdly, the aggrieved party must apply for restitution of conjugal rights. Now, my dear students, let us move on to the constitutional validity of Section 9 of the Hindu Marriage Act 1955. The constitutional validity of Section 9 of the Hindu Marriage Act 1955 has often been a contentious issue in various cases and has been contended to be violative of the right to privacy of the wife. So, in the case of T. Saritha versus Venkata Subbiah, the High Court ruled that the matrimonial remedy of restitution of conjugal rights violates Article 21 of the India's Constitution, which says that everyone has a right to privacy and human dignity. It is observed that women must be given a free choice of their bodies being used for procreation, and hence this provision violates the right to equality for women as well. On the other hand, the Delhi High Court in the case of Harvinder Kaur versus Harmandir Singh has held and took the opposite view, that the objective of the decree of restitution of conjugal rights is to bring cohabitation back between the parties and not to force sexual intercourse. Hence, it was not the right way to hold that the decree would be an invasion of marital privacy. This view was also supported in the case of Saroj Rani versus Sudarshan Kumar, in which the Supreme Court said that if the purpose of the decree of restitution of conjugal rights is understood in the proper context, and if the way it is carried out in the cases of disobedience is taken into account, then Section 9 cannot be said to be violative of Articles 14 or 21 of the Constitution. In the Indian society, this right of the husband or wife is not only created by the Act but is also inherent in the institution of marriage. Even recently, my dear students, in March 2019, the Indian Supreme Court was again faced with a similar question in a writ petition in the case of Ojaswa Pathak versus Union of India. It was contended that Section 9 of the Hindu Marriage Act 1955 violates the personal autonomy of the wife and forces her to return to her matrimonial home. Currently, this case is pending before the 3 judges bench of the Supreme Court of India. Next, we move on to the meaning of the term withdrawal from society used in Section 9 of the Hindu Marriage Act 1955. The term withdrawal from the society of the other not only means a physical separation of the parties but also includes a mental separation. This implies that the act of temporarily leaving a matrimonial home would not amount to withdrawal from the society of the other when there is no intention to withdraw permanently. The following grounds have been held to be valid considerations for living separately, or the grounds on which the decree for restitution has not been granted, such as gross indecent behavior, agreement to live separately, refusal of marital intercourse without sufficient reason, imputation of unchastity by the husband, etc. The following have been held as unreasonable excuses for withdrawing from the society of the other spouse, such as mere frivolity, levity, or impropriety, falling short of adultery, and giving no reasonable ground for belief that it has been committed. Habits of intemperance, the existence of differences, the discovery of pre-marital misconduct, the development of insanity after marriage, which does not give rise to a reasonable apprehension of violence, etc. Thus, dear students, it can be concluded that the matrimonial codes are normally in favor of granting the decree for the restitution of conjugal rights so as to promote stability in the marriage. It is only in those cases where, despite the efforts by the courts for conciliation, the marriage is found to be irretrievably broken, will the courts grant judicial separation or divorce against a petition for restitution of conjugal rights. A similar decision was made in the case of SwayamPrabha Prabha versus Ravindra Kumar, where in an appeal against an order confirming the restitution of conjugal rights, the Supreme Court felt that despite conciliation and much efforts, there were no chances of husband and the wife living together. Accordingly, instead of confirming the order confirming restitution of conjugal rights, the Supreme Court granted divorce to the parties. Let us now move ahead with the second matrimonial remedy, that is judicial separation. Section 10 of the Hindu Marriage Act 1955 provides for the remedy of judicial separation. Under this provision, either party can present a petition praying for judicial separation on the grounds of divorce mentioned in Section 13 of the Act. Basically, once a decree of judicial separation is passed, it shall not be mandatory for the parties to cohabit with each other. It also gives the court discretionary power to rescind the decree if either party files an application in this regard. In other words, a decree of judicial separation is a temporary suspension of marital rights between spouses on any of the grounds mentioned in Section 10. Also, during the course of judicial separation, either party may be entitled to get maintenance from the other if the situation so warrants. But during this period, the husband or the wife would not acquire the competence to marry afresh. The right to a fresh marriage would be available to them only after the marriage is dissolved. Next, we move on, students, to the grounds of judicial separation. Section 10 of the Hindu Marriage Act 1955 provides that the grounds available to either party to file for a decree of judicial separation are the same as those provided under Section 13, subsection 1 of the Act. And in the case of a wife, additionally, the grounds specified under Section 13, subsection 2. The grounds available to either party to a marriage are adultery, cruelty, desertion, conversion, unsoundness of mind, leprosy, venereal disease, renunciation of the world, presumed death. Further, the following grounds have been provided to the wife in addition to the above grounds: bigamy, rape, sodomy and bestiality, non-resumption of cohabitation after a decree or order for maintenance, and lastly, option of puberty. The above mentioned grounds will be discussed in detail on the grounds of divorce in the next module. So let us now discuss the differences between divorce and judicial separation. Firstly, divorce is provided under Section 13 of the Hindu Marriage Act 1955, whereas judicial separation is provided under Section 10 of the Hindu Marriage Act 1955. Secondly, the object of divorce is to end a marriage and is final in nature, whereas judicial separation merely suspends a marriage and is temporary in nature. Thirdly, divorce may be initiated after a period of 1 year of marriage, whereas judicial separation can be filed at any time after marriage. Fourthly, In cases of divorce, the parties can remarry, but in case of judicial separation, the remarriage of the couple is not possible. Fifthly, divorce proceedings consist of two judgment procedures. One is when the petition is filed and the second is after 6 months. Whereas in judicial separation, one judgment procedure is required for judicial separation. And lastly, in divorce, there is no possibility of reconciliation after the divorce order is signed. Whereas in judicial separation, after the passing of the decree of judicial separation, there are still chances of reconciliation. Now we move on to the effects of the decree of judicial separation. Firstly, it is not mandatory for the petitioner to cohabit with the respondent, but the court may, on application by such a party and on being satisfied with the truth of the statement made in such a petition, rescind the decree if it considers it just and reasonable to do so. Secondly, the marriage tie is not dissolved. Thirdly, it is not obligatory for the parties to cohabit with each other. The petitioner, if she is the wife, becomes entitled to alimony from the husband, and if he is the husband, he can claim maintenance from the wife under Section 25 of the Hindu Marriage Act 1955. The decree mandated rights and duties take the place of the mutual rights and obligations arising from the marriage. Now students, we move on to the next matrimonial remedy, that is nullity of marriage. Due to the fact that marriage is by definition null and void, the Hindu Marriage Act 1955 also allows for its nullity declaration. Basically, a void marriage is considered to have no effect on the law from the beginning, and hence it does not lead to the creation of any rights between the parties. This situation arises when either party marries afresh during the subsistence of the first marriage. This would amount to bigamy and hence make the second marriage void. Due to this, the court may pass a decree of nullity at the instance of an application filed by either party to the marriage. The condition for a void marriage is provided under Section 11 of the Hindu Marriage Act 1955 and also includes other conditions such as degrees of prohibited relationship unless the custom or usage governing each of them permits such a marriage. And if the parties are subpoenas of each other, unless the custom or usage governing each of them permits such a marriage, these conditions impose a restriction on the marriage of parties when they have a common lineal ascendant to which both of them are related. Nullity of marriage can also arise due to a voidable marriage, which, though initially valid, becomes void on a decree of the court, up until the court declares it to be null and void. Such a marriage remains in effect. Further, according to Section 12 of the Hindu Marriage Act 1955, a marriage may be voidable and annulled by a decree of nullity on the grounds of impotence, insanity, consent obtained through coercion or fraud, and the pregnancy of the wife at the time of marriage. The main distinction between void and voidable marriages is that a void marriage is void ab initio and is a nullity. It is void ipso facto. On the other hand, a voidable marriage is the one that is valid for all intents and purposes unless the district court decides to annul it on the petition of the aggrieved party. Additionally, Section 16 of the Hindu Marriage Act 1955 protects the interest of children born or conceived prior to the decree's entry in the cases of nullity of marriage as a result of being void or voidable. The children of such marriages have been declared to be legitimate under this section. It is pertinent to note that Section 16 comes into operation only in a case in which a marriage is in fact proved to have taken place between two persons, but which is void under Section 11 or voidable under Section 12. Where there is a case of no marriage between two persons, Section 16 does not apply to the case of the children born to such persons. The next matrimonial remedy, students, under the Hindu Marriage Act is divorce. Divorce, as discussed in the beginning, is the petition by which the parties seek to get separated and dissolve their marital ties. Section 13 of the Hindu Marriage Act 1955 provides for the grounds for divorce available to the husband and wife and to the wife alone, which will be discussed in detail in the next module on dissolution of marriage under Hindu law 2. Let us now come to the conclusion of today's lecture. Thus, in this module, we have discussed the theories of divorce and the matrimonial remedies provided under Hindu law. It is pertinent to mention that the jurisprudential concept of dissolution of marriage in Hindu law is based on various theories of divorce, such as fault theory, frustration theory, irretrievable breakdown theory, and customary divorce theory. Additionally, dissolution of marriage under Hindu law takes place not only through the grounds of divorce, but it may also occur by a decree of judicial separation, nullity of marriage, or refusal of the grant of a decree of restitution of marriage by the court. In all these situations, the marital obligations are initially suspended and later might come to an end. With this, students, we come to an end of today's lecture. I hope you have enjoyed today's lecture. Thank you very much.